Hello and welcome to the TAX3704 lecture series. This is our second lecture. Before I continue, I want to attend to the housekeeping before we carry on with the lecture. Firstly, I want you to know that the focus of the module is primarily on the application of the tax administration provisions. Therefore, it is important that you understand how to apply the specific provisions and when to apply and why are you applying these provisions. Given the fact that the exam is now online, we know that at your disposal you have all the study materials, you have all the guidances, you have Google, you have your friends. So therefore there is a shift in the nature or how the tax administration module is now being assessed. Therefore, you will not be rewarded for just reciting the Tax Administration Act as is in your answer sheets. You have to learn to apply the Tax Administration Act. And it is important that you understand that reciting the Tax Administration Act provisions as your answers as they are is plagiarism. Plagiarism is against the tuition policy at UNISA. Any student who is found to have plagiarized will be subjected to a student disciplinary committee. So therefore, the application of the Tax Administration Act provisions will allow you to give advice to any person or any entity under any circumstances regarding their tax affairs. Moving on to the focus of the lecture. In this video lecture, we will focus namely on the registration provisions, the submission or filing of returns, and the duty to keep records. Like I mentioned in the previous video lecture, this slide represents the core or the tax administration module. The focus, therefore, in this video lecture is on the first two enforcement measures or an administrative power available to SARS in terms of the SARS Act. Looking at the requirements to register. Who must register for tax? In terms of the Tax Administration Act, any person or natural person who derives an income, whether it's from a salary, a commission, or a fee, is liable to register for tax. Corporates are also taxpayers in their own rights. These include closed corporations, companies, as well as trusts who derive income whether in the rendering of services or in carrying out their trade. They are also liable to register for tax. I'm sure you are aware that the definition of a person include companies, it includes those corporations, as well as trusts. Therefore, all these entities are also required to register as taxpayers in terms of Section 1 of the Income Tax Act. However, their registration is not limited to the income tax. Lastly, we have the third revenue stream in the tax system, which consists of the consumption taxes, wealth taxes, and property taxes. The registration in this tax stream is mainly driven by the actual transaction that takes place. So when we look at the value-added tax, any person who is a supplier of the taxable supplies is required to register. When we look at the property transfer taxes, the person who sells or the person who is a trader in a particular property will be required to register for tax. Generally, it is only the natural persons or the individuals and the companies who are required to register under a tax act. The provisions to register under a tax act are dealt with in Chapter 3 of the Tax Administration Act. Chapter 3 refers to the taxpayer registration. Section 22 of the Tax Administration Act provides that any person may register under a tax act, whether on a voluntary basis or under an obligation. You must register as a taxpayer with the South African Revenue Services as soon as you become liable, meaning as soon as you begin to earn income. In the past, the definition was a little bit wider, in that a person who is employed or a person who is working for at least 22 hours was considered to be liable to register for tax. So it has been amended. So now it is only the reference to the earning of income being a requirement to register for tax. This registration must be done within 21 days. The 21-day registration period is a common factor in all the tax administration provisions. Every time there is a deadline that is set by SARS or it is set for taxpayers, it is normally 21 days. Continuing with the taxpayer registration requirement, you are not only required to register, but you are also required to keep your particulars with SARS up to date. Any changes in the registered particulars of the taxpayer must be updated with SARS within a 21-day period. It is important to note that once you are registered, you will be liable for anything that happens under your tax reference number. Next, in the provision of taxpayer registration requirement, we look at what will happen if a person or an entity does not register. In order to ensure compliance to this registration requirement, any failure to register or neglect to register or to notify SARS of the changes in the registered particulars will constitute an offense. Under Section 234, any person who is guilty of such an offense, upon conviction, may be subject to a fine or imprisonment for a period not exceeding 2 years. Lastly, included in the taxpayer registration requirements are the representative taxpayers. These include employers, banks, insurance houses. Representative taxpayers are also required to register. Their registration is provided separately under Section 153 of the Tax Administration Act. Secondly, tax practitioners are also required to register with SARS. Their registration is provided under Section 240 of the Tax Administration Act. Public officers are also required to register with SARS. They must and have to be approved by SARS before they can act on behalf of an entity in which they are appointed. The second provision in this lecture series relates to the submission and the filing of tax returns. Section 25 of the Tax Administration Act prescribes that a return for tax must contain the information that is complete and true. Secondly, all the returns for tax that are submitted to SARS must be signed by their respective taxpayers as proof that the taxpayer agrees with the information that is contained in those tax returns. These tax returns may also be signed by their representative taxpayers, confirming the completeness and the honesty in the information contained in the tax return submitted to SARS. Continuing with the provision for submission or filing of tax returns, Section 25 provides for the correction of errors. If subsequent to the submission of a tax return, a taxpayer discovers an error in the return, it is upon the taxpayer to approach SARS and request a correction of that error. By the same token, SARS is also allowed to request a resubmission or a correction of an undisputed error in any return submitted by a taxpayer. It is important to note that SARS may also require a third party to submit information that they hold on behalf of another taxpayer, or the information they hold about the transactions with another taxpayer, or the information about another taxpayer in their possession. This is provided for in Section 26 to Section 28 of the Tax Administration Act. SARS may also extend the time period for filing of a tax return. In the same token, the taxpayer can also request an extension of the period of filing of a tax return. In the event of non-compliance, included in the administrative powers of SARS, SARS may gather information about a particular taxpayer, information about a particular transaction, information about a particular asset, information about a particular liability. These powers are provided, or these secondary powers are provided in Section 40 to Section 49 of the Tax Administration Act, which also provides for powers to inspect, powers to verify, or powers to initiate an audit of a taxpayer's tax affairs, or to gather any information necessary for the administration of a tax act. SARS will therefore apply these powers whether or not the taxpayer is willing to cooperate. Within the administrative powers of SARS, as we continue, SARS may also, in the event that the taxpayer is not cooperating with SARS, Section 59 to Section 66 of the Tax Administration Act provides for powers to search and seize any relevant information or relevant material necessary for the administration of a tax act. And in that search and seizure operation, any relevant information or material may be seized to facilitate the administration of a tax act. So it is important to understand that these provisions under Section 59 to Section 66 are considered as hostile powers. Before these operations or processes may be initiated, a court order or a court sanction is normally required. Similarly, with the previous provision, any failure or neglect to submit a return or document, or an incorrect statement that is made in a return, or an incorrect entry that is made in a return, will constitute an offense. Such an offense is punishable in terms of Section 234 and Section 235. Upon conviction, a person will be subject to a fine or an imprisonment of a period not exceeding 2 years. Continuing with the provisions for submission or filing of returns, SARS has additional powers. SARS may levy, or SARS has a power to levy both the administrative and the understatement penalty for any non-compliance by the taxpayer relating to the submission or the filing of a tax return. It is important to note that any penalties, levies, or fines that arise of non-compliance with the Tax Act are not deductible for tax purposes, as they are not incurred in the production of income. Moving on to the duty to keep records, Section 29 of the Tax Administration Act prescribes that a person must keep records that enable such a person to observe the requirements of a tax act, to keep records, to also keep records that are specifically required under a tax act, to also keep records that will enable SARS to be satisfied that the person has actually observed the requirements under Section 29 of the Tax Administration Act. The keeping of records is also for the protection of the taxpayer. These records may come handy when a taxpayer has decided to lodge a dispute with SARS, or when a taxpayer is called to discharge his or her burden of proof under Section 102 of the Tax Administration Act. As a taxpayer, you are required to retain these records for a period of up to 5 years. This may become handy in an event that an audit has been undertaken or initiated against you, or in the event that as a taxpayer you have decided or you have undertaken an objection and appeals against an assessment. Therefore, it is important that you retain these records until such an audit has been concluded, or until such an objection and appeals process has been finalized. Lastly, in the duty to keep records, we look at what will happen in the event that a taxpayer fails or neglects to keep records. There are still taxpayers that are still keeping physical documents or physical records or physical information. What will happen if such information disappears or such information is destroyed, which may render a taxpayer non-compliant with the record-keeping requirement? In such situation, you may want to advise the taxpayer to be proactive by approaching any SARS branch or a SARS official in order to report such a situation or such an incident. Secondly, you may also want to advise the taxpayer to consider approaching the suppliers for duplicate records, also to consider obtaining police affidavits. At the end of the day, it is still your responsibility as a taxpayer to keep records of whatever nature, however possible. Remember, Section 102, the onus is on you as a taxpayer to prove that the particular transaction has taken place. It is important to remember that it is you, a taxpayer, who will have to discharge the onus of proof in terms of Section 102. We have come to the end of this video lecture. In the next video, we will be looking at the provisions in respect of tax assessments, provisions for dispute resolutions, and provisions for the recovery of tax debts. Thank you very much. See you in the next video.